Our fifth speaker for today is Mrs. Nkechi Usani. She will be speaking on her favorite sections of the Cross River State Administration of Criminal Justice Law of 2016. Let me give a brief bio of Nkechi. She is the acting chief registrar of the newly constituted Cross River State Customary Court of Appeal. She started her career in private legal practice before crossing to a telco. In 2010, she made a career switch to the public service, where she headed the regulatory department of the Cross River State Tourism Bureau. In 2014, she transferred her service to the Cross River State Judiciary, where she has at various times headed the probate court, the prison decongestion court, a family court, and regular courts within and outside Calabar. Please join me in welcoming to the podium Mrs. Nkechi Usani.
Good afternoon, everyone. It gives me great joy, pleasure. I feel privileged and honored to stand on this stage today. It's especially so looking and seeing my classmates, many of whom I haven't seen in decades. But I have to admit, all of you look really, really good and haven't aged a day. Please give it. Thank you very much. We also do acknowledge the presence of Mrs. Ezugu's son, who was breastfeeding when we were doing criminal law. He says he's studying architecture, but I think he's a law student, at least by association, and we should allow him that. My topic this afternoon is less glitzy than what we've been talking about. We're going to go down to where the dregs of society are. We're going to be talking about the criminal justice administration. It's not an area of law many of us want to go into. We don't want to be called ambulance chasers and all of that, coming before magistrates' courts and the high courts. But the criminal justice system is one of the things that underpins a society that works, a society that has order. And if we really do think about it, I'd like to say that there are more criminals in boardrooms than in the magistrates and high courts and in the police stations, if you ask me. So we're going to be talking about one of the most significant pieces of legislation that regulates criminal justice system, and that's none other than the Administration of Criminal Justice Act of 2015 and its compatriots at the state level, which is the Administration of Criminal Justice Law of Cross River State of 2016. Now, criminal justice before the advent of the Administration of Criminal Justice Act of 2015 was governed principally by two major legislations. It was governed by the Criminal Procedure Act in the South and the Criminal Procedure Code or the Penal Code in the North. The Criminal Procedure Act, like I said earlier, is applicable in southern Nigeria. It started life as Ordinance 42 of 1945, take note of the date, and was reenacted as Ordinance 43 of 1948. I counted about 26 amendments between 1948 and 1990, and I became familiar with the legislation as a law student when it was around when it became Cap 80 of the Laws of the Federation of Nigeria of 1990, and in practice as Cap 41 of the Laws of Federation of Nigeria of 2004. The Criminal Procedure Code, it was enacted by the Northern Region in 1960, and following the creation of states in 1967, applied to all northern states. I'm not sure how comprehensive my research was, but I found just one amendment of that law in 1963. Now, what this means is, like I said, take note of the dates. We had the Criminal Procedure Act that was enacted as Ordinance 42 of 1945. And until 2015, when the Administration of Criminal Justice Act was enacted, that was what governed the administration of criminal justice in Nigeria. Of course, the clamor for change was high, and that was not surprising, simply because the the principal legislations did not give effect to the provisions of the Constitution. So you had the Constitution guaranteeing certain rights of individuals, the presumption of innocence, the right to dignity, to your personal liberty. But these legislations did not give effect to that. They were outmoded. Dinosaurs. They were prehistoric. From 1945. And it had more in common with injustice than justice. Most of those who were the stakeholders in the justice system, it left them frustrated. The complainants, the defendants, the institutions, CSOs, the police, the judiciary, the Ministry of Justice, everybody was left frustrated because, you only knew when a matter was starting. You had no idea when it was going to end. There was mostly no closure. The matters were, the adjudication was slow. Prosecution was slow. There was rarely any closure. No acquittals. No convictions. And of course, it swelled the ranks of those who were awaiting trial in the prisons. You hear it at talk shops and all of that, prison decongestion. But it was until I sat at the prison decongestion court that I understood just the magnitude of it. At the African prison then where I sat, up to 80% of the inmates there were awaiting trial. Many of them hadn't been to court in years and their matters had just fallen through the cracks. They had been forgotten. And so these were the real issues that stakeholders were grappling with the administration of criminal justice in Nigeria. Of course, it was prone to abuse. We had various things where, arrest in lieu, someone went to report you to the police, and if they didn't find you, any of your relations or associates would do. They would pick you up. Of course, torture, the inhumane treatment of detainees. They forgot, everybody knows the Nigerian police. They have no idea what the presumption of innocence is. And if you think that it's just with the suspects whom you come to report, perish the thought. Because even you, the complainant, the tables could turn very quickly, on you. And of course, the system was riddled with corruption. It had, like I said, had more in common with injustice than justice. Next slide, please. This situation gave rise to this quote that I have on the projector. And it was given by none other than another proud product of the University of Lagos, Professor Yemi Osinbajo, when he was Attorney General of Lagos State and presenting a series of proposals for the reform of the criminal justice system in Lagos State. And he said, and I quote, "An effective criminal justice system is fundamental to the maintenance of law and order. Criminal justice, because it addresses behavioral issues, must be dynamic and proactive. Consequently, many of the provisions are outdated and in some cases anachronistic. Besides, the loopholes in the laws and procedure have become so obvious that lawyers, especially defense lawyers, have become masters in dilatory tactics. It has thus become increasingly difficult to reach closure of any kind. In many criminal cases, convictions or acquittals have become exceedingly rare." Next slide, please. Keep taking me back. Okay. And so, of course, like I said, the clamor for change from the status quo had started, but it gained a lot of, it reached a crescendo with the advent of civilian rule in 1999. And of course, as is usual, Lagos State took the lead with the enactment of the Administration of Criminal Justice Law of Lagos State in 2007. The Administration of Criminal Justice Bill of 2004, the ACJ Bill, was the brainchild of the Presidential Committee on the Reform of the Administration of Justice in Nigeria. This committee, through the bill, sought to merge two principal pieces of legislation into one, to be cited as the Administration of Criminal Justice Act of 2005. And I'd like for you to appreciate the fact that this bill had been presented in 2005, but was only eventually passed in 2015. So Obasanjo came and went. Yaradua came and went. Jonathan was going to come and go until on the eve of his going, he signed the ACJ into law. In fact, there are many people who will tell you that that perhaps was the most significant thing that he did. The Administration of Criminal Justice Act of 2015 was applicable to all federal courts, as well as the courts of the Federal Capital Territory. How does it do this? Cross River story. Cross River has always enjoyed a very healthy relationship with the NGOs. I mean, we were home to all sorts, the UNODC, the UNICEF, Fury Law, the MacArthur Foundation, and they really indeed have helped us get quite a lot done. We're not very wealthy, but we can be very ingenious in pushing our agenda. And we've had these partners in progress who have helped us over the years. And so as soon as the Administration of Criminal Justice Act of 2015 was enacted, we kicked into high gear in Cross River. Of course, one of the things that we do very well in Nigeria is hold talk shops, and anything and everything is an opportunity to have seminars, workshops, brainstorming sessions. And we went the whole hog, and it culminated in our signing, the enactment of our own Administration of Criminal Justice Law on the 1st of October 2016. The funny thing was, even though that law was assented to by the governor on that date, we did not see a copy of the law until 2018. And so it was only in 2018 that we were able to begin to apply the law in Cross River. Shadi, are you going to make provision for this pointer? Anyway, the Administration of Criminal Justice Law of Cross River State 2016 is very similar to the Administration of Criminal Justice Act of 2015. It has 49 parts and 492 sections. The Administration of Criminal Justice Act also has 49 parts but 495 sections. It makes robust provisions for the types of arrests, monthly inspections of places of detention, the creation of the Police Criminal Records Registry, the trial of corporations, creation of the regulation for trial times. Slide change. Oh my goodness. Yes. Made provisions for regulation of trial time. So trials had to be commenced within a certain time limit, and if you couldn't, you had to make returns to the chief judge. Ensured, abolished the discrimination against women as sureties and witnesses, data collection and reports, the judicial oversight of detention centers, the abolishing of lay prosecution, the abolishment also of stay of proceedings, made copious provisions for non-custodial sentences, and the power of the court to order payment of expenses, compensation, damages, and restitution. Now we go to my favorites. In my work as a magistrate sitting in court, one of the things that you're hampered by is the fact that you want to do substantial justice, but you find that most of the tools that you have do not allow you to. And where you try to veer, you are accused of being a judicial activist and, instead of lawyers challenging your decisions, appealing against it, they begin to petition you. However, my first favorite is, in order of the sections that they are listed, is the arrest in lieu of suspects. Very often in the magistrate's court, what we found was that where the police, is unable to get to the suspect, then they would pick up whoever it was that they found. I mean, it could be relative, it could be associates. I mean, it didn't matter who. They would bring them, charge them, and you would sit over the matter. And it is only when evidence is being taken that you will understand what had happened. This can no longer happen. Well, we hope so. The humane treatment of suspects. This is something that everybody who has been in a police station knows happens, continues to happen, but the impunity, at least in my neck of the woods, is less than it was before. One of the things, quite apart from torture, regular things like you arrest someone and you ask them, you strip them of their clothes. And when I used to go on inspections of police stations, I used to ask, why are you stripped? Why are they in their underwear? And one of the station officers thought he was being smart and said to me, "Oh, your worship, is because they want to commit suicide." I say he wants to commit suicide because he stole a phone. Okay, so if he wants to commit suicide, how will his trousers, aid his commission of suicide? And if you're worried about the commission of suicide, why aren't the women stripped also? So those were some of the questions that they didn't have answers to. The recording of details of suspects is also something that is very, very important. I remember a case that had James Onanefe Ibori, when I think he was standing for election or re-election, I can't remember. But one of the allegation against him at the time was that he had been convicted at a Buhari magistrate's court for stealing building materials. And one of the things that he said at the time in his defense was that he wasn't the one. Now, if this provision of the law was available at the time and the records were taken, his name, his address, his occupation, facial marks, his height, his thumbprints, we would have been able to say, well, we know it is you. Because, well, if anything, if the events that happened after his conviction in the UK, we know that stealing wasn't something that he started when he became governor. So these would have helped that. And it's also very important for the collation of data, because we have sentencing guidelines for whenever, you hear a matter. And you have mitigating and aggravating circumstances. For generally, if you're in my court and you're a first-time offender, you're not likely to go to jail. But I have no information before me to be able to make that decision, because sometimes, because of the fluidity of movement, someone may have committed a crime and been convicted elsewhere, and then he comes into jurisdiction and you have no idea. An example of this is one time, the national park was in my former court, was in my jurisdiction, and one of the things that happened is that they found a logger who had come in all the way from Akure to log in the national park and had been brought to me. And so those are just some of the provisions that make life easier and give effect to the meaning of the administration of criminal justice. The recording of confessional statements is another one. We haven't gone so far in Cross River State because it makes it still discretionary to record confessional statements. The remedy of suspects detained in custody, very, very important, because, of course, we know the police, they just pick you up and they dump you there. Now, you can come before a magistrate and make an oral application, and the magistrate can make an order based on your oral application to either grant bail or compel the police to bring the matter to court. Judicial oversight detention centers, I can't say enough about it. Every month, I have to behave like a James Bond and devise new means to inspect police stations so you don't tell them. There was a time, so in my jurisdiction, I used to have the area command and the police station. Now, what I used to do was I used to reverse roles, and surprise them. I'd be coming from work, and I'll just park my car in front of the police station and call my registrar, my clerk, and say, okay, come and meet me here. And on one of those such occasions, I saw them, basically carrying someone out in his underwear out of the station, and they were scrubbing his name off the board. And I said to him, where are you taking him to? He said, no, he's not a suspect. He's not a detainee. We are releasing him. I said, you are releasing this person that you are jacking to the back like this. And that's what happens very often in our police stations. Non-custodial sentences. It is such a welcome development. As someone who has sat in prison, the congestion court, I cannot say enough about it. Too many of the offenses for which people are detained are not necessary. They have no cause to be there. No cause, absolutely no cause. It is a travesty that over 70% of the people who are detained in our custodial centers are people who are awaiting trial. And so that's a welcome development. The power of the court to order payments of expenses, compensation, damages, and restitution. This is also one of my favorites. There was a matter that I did shortly before I was appointed as the acting chief registrar, where a man had been married to a woman, and the marriage had produced, I think, eight children, 5 boys and 3 girls. And the man decided he wanted to marry someone else. And the woman said, fine, you can go, but you have to leave me with something to train these 8 children we have had together. And so the community mediated, and they gave her pieces of farmland, which she gave unto her sons. The man fell on hard times and decided that he would come back, to collect the farmland. And the community said, no, you cannot do that. And so what did he do? He used our hired guns, the police, started harassing the children and all of that. Went so far, I can't go into the details, but he went so far, had them detained and all of that. And when the matter came before me. And as it began to unravel, I saw what it was that had been happening. And when I eventually gave judgment in that matter, I ordered compensation to be paid to the children. And I also fined the police officers who had been used to cause those children to harass them. Next slide, please, before Shade beats me. It's not yet Uhuru. There's a lot to be done. There is a lot to be done in spite of all the wonderful things that the Administration of Criminal Justice Law allows us to do. But it's not yet Uhuru. Funding, Owonikoko, N&K. It is very important. You can speak all the grammar, you can make all the nice laws, but if there is no funding to give effect to those things that you do, then it is rubbish. We need the human resources, the IT resources, the advocacy for all stakeholders. Many magistrates, many judges do not understand the powers that they have in the Administration of Criminal Justice Act and law. We also need to strengthen the institutions. Legal Aid Council. Many of the people who are in my court are indigent. They have no idea. Now, in my court, they know that if you're a first-time offender, it's unlikely that you're going to jail. So what the prosecutor does is tells them, when you go before, just tell her you are guilty. It's a crime. She will give you community service. You know? But if many of the times, that's also because the police do not have the ingredients. Laziness, lack of manpower, no forensics hampers their investigation. So if they can secure a conviction by asking the suspects to plead guilty, then they'll do that. And that's where it's becomes important to strengthen institutions like the Legal Aid Council, the judiciary, the police, the CSOs, and just to give effect to what it is that this beautiful piece of legislation is supposed to do. I believe that's it. Thank you very much.
Right, and I have one for Nkechi as well. Benchmarking with other states in Nigeria. Where can you place the Cross River State Administration of Criminal Justice Law of 2016? Welcome, sir.
Thank you very much. I'm particularly fascinated by the presentation by Yvonne, because that's my own area of interest. Now, when you concluded, you mentioned some problems, with going forward. Particularly because you are a chief registrar, you may be able to take this forward. One problem that I have seen with attempt to implement the Administration of Criminal Justice Act and laws is that we've not taken time to do a costing of what it will cost, what it will take to implement all the provisions. Even Lagos that has started since 2007, at the last count, the police has only 2 statement-taking rooms fully equipped in the whole of Lagos. So we need to, the judiciary, you can take a stock. What is it going to cost for us to implement the aspect of the criminal justice that concerns the judiciary? If you ascertain the cost, then you can then have a plan of 20, 25 years. If it is 50 million we will devote next year, then the subsequent years, then over a period of time we'll have implemented it. Otherwise, you will be amazed that in 50 years, we will have provisions in that law that have not been implemented. So I think that's something that I just wanted to chip in. Thank you.
So my question was where I can place the Administration of Criminal Justice Law of Cross River State, benchmarking it against other states. I think we fared very, very well in Cross River in terms of legislation. We were the first state in Nigeria to enact sentencing guidelines for child offenders, right? Yeah. So we've done very well. We've enjoyed the partnership of INGOs. It's taller here. I learned that this morning, of international NGOs. And usually when those sort of partners are involved with you in law, legislative enactments, you're usually exposed to best practices, especially since most of the times they're the ones funding it. So we measure very, very well against other states in Nigeria with the ACGL. I know the Lagos State the Lagos State version has undergone very many amendments already. We're not quite there yet because, like Prof said, we haven't, because of the issues around funding, and advocacy, we haven't explored most of the provisions of that law. But in terms of benchmarking the actual provisions, we've done very well in Cross River.